Okay, this is video 12 in the Gerhardt Konig trial, and I think this is actually going to be a two-parter this morning because I got a lot to say about nothing. So here's what happened yesterday. It was Monday in court. I anticipated a big day. It was not. What it was really just about an hour and a half. The jury wasn't there. The defendant wasn't there. His head defense attorney was not there. They brought in the kind of secondary defense attorney to argue a motion that they had filed on Friday, I believe, about suppressing some evidence. I'm going to talk for a while because there's a lot of moving parts. The defense has filed a motion to suppress some specific evidence from being put into the record or for the jury seeing it. It is Exhibit 107 that the prosecution, basically it's like the bundle. It is the results of the search warrant that they served on Gerhardt Konig's laptop. Now, this search warrant included a bunch of like parameters. So it was his laptop, like the physical laptop, the hard drive, and then the cloud storage. So it was like any of the storage that was associated with it. It had specific dates and it had specific keywords. I mentioned some of those in previous videos, but here's the full list. It's cliff, puka, trail, oahu, trip, danger, death, fall, slip, accident, climb, hike, body, kill, die, WhatsApp, Ari, Ariel, Jeff, Jeffrey, Jeff Miller, affair, infidelity, cheating, syringe, vial, incapacitate, divorce, separate, undetectable. Those are all the different words that they put in. I may have missed a couple of them, but that's the gist of the list, right? It's a lot of it. On Friday, they had Detective Enuma in, and he was explaining as best as he could how he executes the search warrant. So he goes into this Axiom software, he puts in the dates, and he puts in all of these keywords, and then it identifies any emails, searches, Google searches, different websites that would have been visited, anything that would have taken place on that laptop during those dates that has that word in it. Now, it returned over 2,300 items or hits, and these aren't just emails, these are like objects, right? When the defense presented this motion, they said they used the word separate as an example. So the prosecution is using it as separate, meaning separation of marriage, meaning you get separated before you get a divorce. So that's what they were searching for, but the word separate, they believe, the defense believes, is also coming up in a different context and shouldn't be part of this. And so what they're saying is that the search warrant was not executed properly, that there's something wrong with the Axiom software because it's pulling the word separate, and where it's pulling it from is not from emails or searches. It's pulling it from the source code instead of actually the body of the content. If you're 10 steps ahead of me, you can fast forward while I kind of explain this out loud to make sure I understand it and everybody else understands it. So for example, if you're searching for a date, if you're searching for the number 1979, right? You're looking for that year. Well, what could happen is, yes, it could come up in different emails. It could say, you know, this person graduated in 1979, or this was happening in 1979, but it could also come up in part of the source code. For example, what it'll return to you is it will give you an email of somebody who has the numbers 1979 in their IP address. This is an example. So if their IP address was like 361.197163466, it would still come back because somewhere in there is 1979 in sequential order. So what the defense is saying is that the word separate shows up in some source coding, and they gave 4 or 5 examples of different emails. So like on this page and on this page and on this page, they're showing where items came back where the word separate was part of the source coding. Now on Friday, the judge denied this motion. He said he felt that this search warrant was obtained in the right way, right? They had probable cause. They went to a judge. The judge signed it. The search warrant was obtained correctly, and then it was executed correctly. And he was trying to be nice about it, but in my simplistic words, he was basically saying, just because you don't like the results doesn't mean you can throw out the evidence, right? Like, you just can't. But he basically said, I'm not going to toss out Exhibit 107. So the defense begged, they said, please just give us until Monday because we really think if we went through this, I think they thought if they went through basically line by line by line, they would find enough examples of these anomalies where they could convince the judge that this evidence should be suppressed. Now, I'll give the guy some credit because he apparently had a very busy weekend. He read through a lot of this. He, again, was able to find, I think he cited 4 or 5 different examples where the word separate was in the source coding, not in the body or the context of the email. I think that is valid. And if I were the judge, I would say, okay, then let's toss out those 4 pages. Those 4 emails will be excluded from the jury. That's what I would do. I would say, great, you've identified these 4 anomalies. Let's take them out and let's move forward. But the judge, again, denies the motion because he's like, your motion is to suppress this under the belief that this was a badly or falsely executed search warrant. And it wasn't. It was obtained properly and it was executed properly. You know, if there are some anomalies within the information that it received, we understand that. And I personally think you can explain that to the jury, like ignore the ones where the words are in the source coding. But the defense was really hoping to have all of this evidence thrown out. So this is why they're fighting so hard. They really need this thrown out. And the judge said no. So then the guy tries again. He's like, but Your Honor, like they need the last word. They want to get it on record. He's like, I just want to get it on record. And I think the reason they want to get it on record, this is just me, hypothetical, but it helps with your appeal. If you can say, we tried 7 different ways to get the judge to toss out this evidence and he wouldn't listen and we think that was an unfair decision. So he keeps going. He's arguing that the search is so broad. The word hike shows up 299 times and the word body shows up 265 times. And his argument is, doesn't that seem unusual? And my argument is, maybe your client's a fucking creep who's talking about murdering his wife on a hiking trail. Like hike shows, maybe not hike, but the word body shows up in your emails 265 times. And let's pretend like it was something benign, like they're talking about an auto body shop or whatever, and the word body shows up. Again, couldn't those emails be isolated and removed before it goes to the jury? And basically the judge is now arguing with the defense. He's like, no matter what you say, you're not changing my mind. We are not suppressing this evidence. And the man is saying, I just want it like on the record that this search returned a lot of items that are not relevant to this case. And the judge said, yes, but the police didn't pursue any of those others. As soon as they realized it wasn't relevant, they stopped pursuing that particular path. And he compared this to a search warrant that the police would execute on your home. And I'm just gonna, this is not the example he used, but this is what I'm gonna do to get to, again, help myself understand it, maybe help some of you understand it if you don't already. If they execute a search warrant on your home, like the police come to your house with a search warrant because they suspect you of robbing a bank, and they have reason to believe that there's bags of money, the bank's money, in your home. They can get a search warrant, a judge can sign it, they can come to your home, and what they're searching for, the search warrant will say, here's what we're looking for. They are looking for bags of money. They're looking for money from the bank in your home. If they come in your home and while they're searching for the bags of money, they discover you have a meth lab in your basement, they are allowed to, because they're now on site. The warrant got them in the door. Although they were looking for one thing, they've now found evidence of another crime. So they are allowed to start investigating that other crime. And it might mean more search warrants. It might mean something different. It might mean going down an entirely different course. But because they have physically witnessed this other crime taking place, they're allowed to pursue it. Whereas with the digital search warrant, they're not allowed to. So for example, again, if they pulled up an email that had the word body in it and they discovered that it was auto body, and then there was pictures or attachments, and they discovered that Gerhardt Konig is stealing cars and running a chop shop at his neighbor's auto body shop, they couldn't pursue that. They would have to go and get another search warrant in order to read those emails and go through those files in his computer. Anything that is not relevant to this case, they aren't allowed to look at and they're not allowed to use. Now come right back. The next video won't be as long, but I do have more to say on the subject, so please come back.